we, the advocates appearing for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, your lordships, on Article 165, Clause 4, on the constitutionality of the constitution of this bench to hear these three specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, your lordship, that the so-called empanelment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, it is our reading that the only person who has the capacity to empanel a bench is a Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, your lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 Clause 4? What was the necessity of the delegation of this function? Those are pertinent issues, your lordship, that requires clarification before we go to the roots of the matter, the crux of the matter. It's our submissions, your lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That's why the Constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, your lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That three files have graciously generated expediency, and other files that were consolidated, that 6 file with the lead file 522, have no reasons why they should be before you. Noting that, your lordship, those matters were equally certified as urgent and raising heavy constitutional matters. When I looked at your orders, your lordship, that you issued to serve on us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority, and that the files with orders are the only ones that the court is sitting on a Saturday?
And overrated the president, which in our view lies squarely within the domain of the Supreme Court. So we once accorded an opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my Lord.
Well, for the first interested party.
Mr. Goa, just a minute. I was about to interject when when Council,
Ndegwa?
Yes, Mr. Ndegwa was addressing it. And that is exactly why I wanted to. I wanted us to have order in the way we conduct these proceedings. And I was about to ask Mr. Ndegwa, after all that, what is your application?
Your Lordship, I'm very clear in my application.
My application for which
the application can only come after I have spoken.
we are now making an application. You respond.
What is it that you want?
Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4, to empanel this bench. Your Lordship, this is the background of my application, that on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 506. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject to seek your guidance. My name is making an application before this bench complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application, and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuation and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without